Howdy, everybody. My name is Brian Foley. We are here today talking about Texas Penal Code 7.22. It is on criminal responsibility for corporations, limited liability companies, things like that. So we are actually going to start with this case from the Texas Court of Criminal Appeals. I think in order to understand the law, you really kind of have to understand this case first. And this is a quote from it. Today, the general rule is that a corporation may be held liable for criminal acts performed by its agents acting on its behalf. And this case, Vaughan and Sons Incorporated versus State, was a criminally negligent homicide case. There was a truck owned by this Vaughan and Sons Incorporated, driven by an employee, and the car was basically left on a highway, like in the middle of the highway, and another person ran into the back of it because that was totally unsafe. They didn't put up any measures. They didn't put up a flare. They're supposed to have all these things. You ever seen a truck on the side of the road and it has all these, you know, warning signs basically that it's there, and it's on the side of the road, right? Instead of in the middle of the road. And so the DA charged that as criminally negligent homicide and prosecuted the company in addition to the person who was in the vehicle. And so prior to the 1974 Penal Code, and under the common law, which is like judge-made law only, which is what we had before we have written statutes and a penal code, there was this common law. And it said that a corporation could not be held criminally liable because it can't form an intent. Interestingly enough, this is a negligence case, so there is no intent really. It's a negligent intent. But you have to understand that context. This wasn't even a thing before the Penal Code section. Okay, so now let's take a look at the Penal Code section. And we're going to skip the first part of the Penal Code section, which is really confusing. And that's why you need to read that case. The first part of this Penal Code section 7.22 says that a corporation can be found liable criminally if the legislature hasn't specifically said they can't be. It'll come up in various situations. We'd have to look at those individual statutes to make sense of it. But this second part here, it says a corporation, an association, a limited liability company, or another business entity can be criminally responsible for a felony offense if it is committed or authorized, by one of these following groups, right? A majority of the governing body acting as a corporation, or a high managerial agent acting on behalf of the corporation. And this is critical because some agent of the corporation can be liable, like in the other case we saw. But for a felony, it has to be one of these two different things. And we're going to come back here to Vaughan and Sons, and here's the holding from Vaughan and Sons, and it is the main impetus here in Texas law for this statute 7.22, assigning criminal responsibility to corporations. It says, we reject the reasoning of the Court of Appeals and conclude that a corporation may be criminally prosecuted for the misdemeanor code offense of criminally negligent homicide under the Penal Code 19.07. And so, again, we see the distinction there between, we have a felony offense. If you're going to charge them with the corporation with a felony, it has to be from a high-level acting person. So this probably wouldn't have played out if it was a felony offense, but they went with the misdemeanor criminally negligent homicide at the time. In 1987, there was a misdemeanor version of that. So that is Texas Code of Criminal Procedure 7.22. I hope you enjoyed that. Remember, this is for educational purposes only. Like and subscribe if you like what you saw. Thanks so much.